Hello, and welcome back to Chapter 15 in Healthcare Law and Ethics. We're finishing up with Section 5. We're starting on page 367, and we're going to be talking about how we manage the release of information process. Now, this process should be part of an organization or a provider's information governance program, and it's essential to ensuring that a healthcare organization or a provider is providing the appropriate safeguards necessary for protecting the privacy, confidentiality, and security of PHI. Now, when we get back into this, we have to go back and we have to make sure we have a good definition for our legal health record and our designated record set. So we talked about that in earlier chapters. Now remember, our legal health record serves as the organization's business record, and if there is a request for information, that is the record that is released upon that request. Our designated record set, remember, it's broader than the legal health record, so it not only consumes or includes what's in our legal health record, but it also is going to include our billing information, our insurance enrollment and coverage, and then any other documents that are used in whole or in part to make decisions about the individuals. Now, if we flip over to the next page, it continues on. Be sure to read through that. Again, we're going to keep these lectures short and sweet and just hit the high points. So let's get into that next, that last question here. Who's responsible for disclosing information? So we're jumping down to the next paragraph. So a determination has to be made to determine which departments are going to disclose or release information when it's requested, since your PHI and electronic PHI can be stored in multiple forms and multiple systems. So departments may be responsible for processing requests for records that are under their control. And a good example of this would be your radiology department. Okay, I'll give you an example. If a patient comes in and they come to the HIM department and they say, I need a copy of an x-ray that I had done. One of our first questions we ask that patient is, do you need the x-ray film or do you need the doctor's interpretation of the x-ray? Because those are two different things. You have the image of the actual bone that was x-rayed, and then you have the doctor's recorded or transcribed interpretation of what he sees when he looks at that image. The HIM department at Tupelo, they only release that doctor's interpretation. You have to go to the radiology department to get a copy of the actual film. So again, you have to determine who's going to release what. Is the radiology department going to release x-rays? Is the lab going to release lab results? Now, a lot of times, the best way for this to happen is for HIM department to handle all of the different requests. The HIM personnel would be responsible for gathering all the requested documents, such as the health records, billing office records, x-rays, and then releasing them to the requester. But again, that's not always the easiest. So sometimes it is still easier if that patient wants a specific image, to go to the department that houses that image. All right, let's talk about the different types of requests that you can receive. So requests for access, use, and disclosure or release of information commonly occur through mail, the telephone, or a physical presence of the requester. So this could be either an unannounced walk-in or a prearranged on-site request. So they want to come in. They've requested to come in and review the chart. Requests may also be received electronically via fax or email. In addition, a requester may ask that information be faxed or emailed to a given location or sent electronically via a given website. Now, let's go through this list. So, verification of requester. You have to know who is actually requesting the information and whether or not it's a valid request and they have a valid authorization. So, there's certain pieces of information that we've talked about. You need to know their name, maybe their date of birth, their address, their phone number, other information that person would know about themselves that someone else may not know. Okay, so again, you can receive mail. You can receive mail from an attorney's office. You can receive mail from a patient. You can receive mail from workers' compensation. Telephone, anybody can call. You can have an insurance company call asking for a discharge date for one of their patients. You can have patients call in and ask for information. Electronic request, if a patient is in a physician's office, let's say they were in the ER yesterday and they go back and they see their primary care today, or they got into urgent care today to see a doctor, they may call and request information be faxed to them so that they can help continue to treat that patient. Walk-in requests. People walk in off the street all day, every day, saying, hey, I need a copy of my op report from last month for my insurance, or, just random things. And then again, on-site request, someone could call and say, hey, I don't really want a copy, but I would just like to come and see what's in my medical record. And they can have an appointment set up, and they come in and they can look at that paper chart, or they can log in as a manager. A manager would sit with them while they review the document, and the manager would actually help them navigate the system and see where the information lives in each report. And then, of course, fax request again. They want information faxed back to them electronically. So that would be other physicians' offices, other hospitals, things like that. All right, let's talk about verification of requester. All right, so because providers are not always aware of family situations or other relationships, proof of the requester's relationship to the patient must be verified before health information is disclosed. And of course, this is part of the privacy rule. Now, such verification generally applies to in-person disclosures in which information is not being released to a destination specified and authorized by the patient. For example, contracted reviewers and representatives of insurance companies or other payers should be required to present documentation of their relationship with the company they represent. A patient's personal representative should also be required to present documentation to appropriate personnel to verify that the requester has a legitimate right to access the information. Now, dropping down just a little bit, the validity of the authorization should be verified before information is released. Specifically, the following should be done. Check to make sure that the applicable parts of the form have been completed. Make sure that the information does not appear to be falsified. Check the date and authorization to be certain it has not expired. Compare the patient's signature to the one in the actual health record to ensure validity. And exercise good judgment to ensure that there's no suggestion in the authorization or circumstances surrounding it that the authorization was not given freely, that releasing the information would damage the relationship between the patient and the facility in which he or she sought treatment, or that disclosing the information would be harmful to the patient. Now, in addition, all responses to requests should be noted in the organization's procedure for managing requests. It's important for those managing ROI functions to understand each type of request and clearly establish the procedures to respond to the request in a time frame set forth by the organization's policies and then your federal and state regulations. Now, it goes through an example of each one of the different types. So if we go back to our slide, it goes down that list. So mail request. So the most typical request is received through the mail. So they receive a letter or a form and they want information. Be sure to read through each one of these. It gives examples of these as well. On the next page, it gets into your telephone request. They can come from your physician offices, insurance companies, or patients. Electronic request, you can see down there. Let's see, it talks about how there may be a request to fax or email patient information to a given location. Walk-ins, again, most unannounced walk-in requests are from patients who wish to inspect or obtain copies of their records. And it talks about how third parties can also present themselves unannounced. So instead of calling ahead, they just show up. And then you have on-site record review request. So you may have different kind of walk-in request or an on-site review that's prearranged. And then lastly, let's determine whether or not a disclosure is appropriate. So over on 371. Once it's been determined that a request is compliant with HIPAA and state regulations, an organization must determine whether the information can be disclosed. State and federal laws should be consulted to ensure no conflicts exist between the two. In addition, records related to adopted children, mental health, substance abuse, HIV and AIDS, potential lawsuits, genetic testing, or minors receiving treatment not requiring parental consent warrant special protections when disclosure or access has been requested. Now, if there's no conflict, then the next step, of course, is to determine what content is requested. Now, a lot of times people state in their request any and all records. Well, that's problematic because you could have records stored in all different ways, in all different systems, in all different places, and that's just hard to find. Any and all is not an appropriate way of requesting. So, requests for any records should be compared to the HIPAA minimum necessary requirement. Okay? So if it doesn't meet the minimum necessary requirement, it has to be sent back to the contender or the sender for clarification. So if this is an insurance company or this is a law office, they cannot tell you they want any and all records. They have to give you a firm starting and a firm ending date. Now, a patient can come in and say, hey, I want a copy of every record you have for me. We would honor that request. We would tell them that it would take time, but if it's someone else, minimum necessary is going to apply. All right, so continue reading through that paragraph. I'm not going to read all that to you. Now, when we get into subpoenas and court orders, so of course there are times when a health record is required for litigation, and we talked about this in earlier chapters, such as your malpractice cases, maybe car accidents, criminal cases, and divorce proceedings. Health record is produced for discovery and litigation purposes through the use of subpoenas and court orders. So, of course, the subpoena is a legal tool to compel one's appearance at a certain time and place and testify. So that was our subpoena ad testificandum. And then the other kind of subpoena is the ones where we want to actually bring those tangible items, those medical records with us, and that's our subpoena dicus tecum. Now, a court order, of course, is our document that's issued by the judge, and it compels a certain action, such as testimony or the production of documents, such as health records. So subpoena, we talked about that could be done by a lawyer, and a court order is going to come from a judge. Okay? All right, so be sure to continue to read through that section. Let's go into ROI reimbursement and fee structure. Now, the release of health information is a function of doing business and thus has a cost associated with it. The HIPAA privacy rule permits reasonable cost-based charges for labor, postage, and supplies when fulfilling a patient or personal representative of the patient's request for PHI. If the patient request is an electronic copy of his or her PHI that is maintained electronically, the charge may not exceed the flat fee of $6.50. Now, this was changed just a few years ago, okay? It used to be you could charge them $1 per page, up to $20. So even if they came in and wanted 3 pages, legally you could have charged them $20 because no matter how many pages it is, 1 through 20 was $20. And then 21 through 100 pages was $1 per page. And then once you hit 101, it dropped to 50 cents per page. But now, because of these changes and regulations that happen, $6.50 is the max you can charge any patient for a copy of their medical records. Now, that does not go along with what you can still charge for lawyers' offices and things like that. You can still charge them a more expensive fee because, again, that labor is more intensive than just when a patient comes in and requests a record. All right, HIPAA prohibits a CE to pass along cost of using a release of information service to the patient. So if you have a ROI service that's going to be doing the copying, like you outsource your release of information, you can't charge extra for that to help pay for the release of information company. So that's what that's saying. And then it continues on saying providers should determine cost-based fees for their operations, taking into consideration state laws on release of information cost and other state and federal programs such as the Social Security Administration Electronic Record Express Initiative, CMS's ESMD system, and meaningful use incentive programs. Now, You can look at figure 15.3 to look at the cost that's factored into release of information cost. And then over in 15.4, you can look at steps in assessing costs for e-discovery. So you can read through those. I'm not going to go into all of the detail for that. If we flip over to page 374, we get into our accounting of disclosures and tracking releases. So again, we've talked about accounting of disclosures. Privacy rule requires that tracking and accounting of disclosures. It is currently includes all the disclosures made in writing, electronically, by telephone, and orally, except, of course, if it was an exception, as we talked about in Chapter 11. A manual or an electronic tracking system to account for requesters and recipients of patient information should be in place, along with the policies and procedures in support of the process. Most health record copying services also use ROI tracking systems, and you can see that in Chapter 15 or Figure 15.6 over on page 375. There's a flow chart there that you can look at. Now, the right to request restrictions. So, the privacy rule gives patients the right to request that covered entities restrict uses and disclosures of their PHI for carrying out TPO. Covered entities were not required to agree to these in the past, but HITECH enables an individual to restrict an organization's ability to disclose information to health plans for payment or operation purposes if the service provided was paid for completely out of the individual's pocket. So remember, those services that you did not want your insurance to pay for. Now, a lot of people aren't going to do that, okay? They're going to let their insurance pay for whatever their insurance is going to pay for. Some people may have a different moral code, though, and they may feel like, well, these tests aren't medically necessary. My insurance shouldn't be paying for this. I'm going to pay for this out of my own pocket. Well, at that point in time, if I'm paying for it out of my own pocket, I can ask that hospital, please do not send any information to my insurance company. I'm going to pay you in full out of pocket. And so they should comply with that through HITECH now. All right, let's talk about the reasons for refusing to give out information, okay? So in some certain circumstances, it may be necessary to refuse the disclosure of patient information or require additional information or documentation before information is disclosed to the requester. When situations occur like this, it's important to have a process in place, especially a legal counsel, someone that you need to go to. And you may have a provider's medical identity theft committee, for example. So you could have something in place within your organization. Now, reasons for refusing to disclose information or requiring additional information are as follows. And we've got several bullets here, so we'll just kind of touch on each of these. So first of all, the identity of the person presenting the information is in question, or the authorization appears to have been completed without the patient's knowledge or after the patient signed the form. So again, we could be talking about medical identity theft. You know, we may be having a person picked up a blank form and they want to get their neighbor's information. They see that neighbor has such a nice house and a nice car, and they think, well, they can pay for my health care too, and, you know, try to steal their identity and get their information, get their social security number off of something for some, people do crazy things. So they may refuse to release information for that reason. If they feel like the person presenting the form is not the right person, or if it was completed without that patient's knowledge. Okay? Second, if there's a reason to doubt that the person requesting the information is the person named in the authorization. So a lot of times these days, you go into your clinic to see your physician, and they may tell you, well, I need an updated picture. We don't have your picture on file. And they take a picture of you at the front desk. Well, what they're doing is they're using that picture to later identify you as you continue to come into that clinic for treatment. So the next time if somebody comes in and they says, hey, I'm Tiffany Tubb, I'm here to see Dr. Walton, and they have a picture of Tiffany Tubb on their screen and the person standing in front of them is clearly not Tiffany Tubb, then they know something's going on. Okay? All right, the person who signed the authorization is not of legal age. Well, if I'm a 16-year-old and I've not been emancipated and I'm trying to come in and I'm trying to get a copy of my records from a surgery I had last month, well, sadly, I can't get that as a 16-year-old, a non-emancipated minor. So my parents would have to come in and sign that authorization to release those records. Next, there's a question as to the competency of the person who signed the authorization. So again, we cannot, a lot of times we do not release information to incompetent persons. They will have a personal representative that we would release it to instead. All right, there's a question as to the legal guardian of a minor or an incompetent patient, or there is documentation of abuse noted in the record. So if for some reason a mom comes in and she wants to get copies of her 7-year-old child's records, but there are notes saying that there's possible abuse from the mother, then we may not release those records to her. All right, the patient has stated that the authorization should not be honored or has revoked the authorization, and the healthcare organization knows that the authorization has been revoked. So I could have put an authorization in with the end date of 2 years from now. And it's saying that my husband can go in and he can pick up my weekly lab results. Let's say I have to go in for testing every week for something. And I call that hospital and I talk to the HIM personnel and I say, I no longer want my husband to come in and have access to my lab results. I want to revoke the authorization that you have on file. Well, they now have that information that I do not want him to come in and get it. So they will not release that information to him. All right, the next one, the expiration date or the event has passed. So again, if I have that authorization on file and it has that end date of 2 years from today, well, 2 years and 2 days from today, I can't go in and get the same information I've been getting on that weekly basis. I have to complete a new authorization with a new end date. All right, if there's any question to an authenticity of a patient's signature after the comparison, then they might not give you those records. So if you don't have your ID's typically asked for. You go in and you try to get records at Tupelo, they're going to ask to see your ID. If you do not have your ID, then they will compare signatures. But if the signature on the form, the authorization form you're completing, does not match what they see you signed on a consent form last month, then they're going to have some questions there. All right, if there's a question about the patient's ability to understand the authorization, if they just can't get it, they don't understand what's going on, then they may hold off on disclosing that information. There is false information in the form or the form is incomplete. If it does not have all the necessary items filled out, or we know that they're not telling the truth, then we'll hold off on releasing that information. All right, and the last one, if there's a question about whether the patient signed the authorization under duress. So let's say that my husband is beating me and he forces me to go to the hospital and he's with me, so we're both standing there at the HIM desk, and it's quite clear that I was forced to sign that form, even though I didn't want to. Maybe I'm just so scared of him that I signed it. Then they may question that. They can see that. ROI personnel are very suspicious people just because of what their job is. No one wants to release information that they should not have released. So they are hyper vigilant in paying attention to body language and looking at people and ensuring they have the proper information, the proper ID. And so if they can tell that I am extremely uncomfortable and really don't want that information to be released, then they may come up with some reason as to why they can't release that for me. All right, it says whenever possible and appropriate, requesters should be assisted in completing proper authorizations so that the request can be honored in a timely manner. So HIM is still very helpful, and they will help you complete that form. So if you come in and you really don't know what you want, like let's say you come in and you say, I was here for 3 months in the hospital and I want my full record. Well, the HIM staff know that a lot of that information is not necessarily helpful to a patient. They may not understand it. So like a lot of the nursing documentation from the nursing rounds that happen daily, multiple times a day, that generates a lot of paper. And so instead of handing them all of that paper that will not be any benefit, They may tell them, well, I can give you an abstract. I can give you your radiology results, your lab results, and all of your physician reports if you think that would meet your needs. And so it cuts down on a lot of confusion for the patient, and it cuts down on the work for the HIM department as well. All right, so let's look at the check your understanding here, and we're going to be completely finished with law and ethics. Can't believe it. We've made it to the end. Congratulations. All right, so number 1, documents not considered part of the legal health record, for example, correspondence, incident reports, and information about family members, should be released as part of the legal health record. Well, we didn't necessarily read that today, but if you go back to that section over on page 367 and then over into 368, it's going to talk about that. That answer is false. You are not going to release correspondence. Remember, we're not even supposed to put incident reports in the health record itself. And then, of course, we're not going to release information about other family members. So that is false. Number 2, proof of a requester's relationship to a patient must be verified before health information is released to the requester. That is true. HIM is not going to release information to some random person coming off the street saying that they're your aunt. It's not going to happen. They're going to verify. There has to be proof. Number 3, regardless of the type of request made, if the request is from the patient, a formal authorization form is required per the HIPAA privacy rule. That answer is false. Remember, that was one of the exceptions. The patient does not have to complete an authorization form to receive copy of their records. Now, there may be a form completed if you go to the HIM department, but it is not a true HIPAA privacy rule authorization form. That's just their form so that they know what information they've released and to whom. Number 4, health organizations and providers may charge a reasonable fee as set by state law for copying health records in response to a request for patient information. That is true. And number 5, HIPAA requires that for a purpose of accounting disclosures, only PHI that has been released electronically or in writing must be accounted for. And that's false. We already talked about it. Said in the accounting of disclosures paragraph, it included anything in writing and anything orally. So not only electronically or in writing, it could also be by telephone or orally. All right, good luck and happy studying for your Chapter 15 test for Thursday. And good luck and happy studying for your final exam. If you have any questions, please be sure to let me know.